Hello everyone, welcome to MAYANK LAWHOLIC. In this video, we will discuss Delhi Higher Judicial Services Preliminary Examination of 2013 paper. Now let's get started from question number 1. Assertion. The principles of equality before law means that there should be equality of treatment under equal circumstances. Reason. All persons are not equal by nature, attainment or circumstances. Find the correct response. Here the correct answer is correct. Option 1. Both A and R are true and R is the correct explanation of A. Now let us see the question number 2. The Vice President of India is elected. Answer is by electoral college consisting of all the members of both the houses of parliament in accordance with the proportional representation by means of single transferable vote and by secret ballot. This is the correct answer. Prorogation of the house means the session of the house has been terminated. Question number 4. Give correct response regarding the procedure of passing of bills in parliament. Options are: a bill pending in parliament shall not lapse before the propagation of two houses of the parliament. Option second, a bill pending in Rajya Sabha which has not been passed by the Lok Sabha shall lapse on its distribution. Option 3, a bill pending in Lok Sabha shall not lapse on dissolution of Lok Sabha. And option 4, a bill pending in the Rajya Sabha which has been passed by the Lok Sabha shall lapse on the adjournment of the Rajya Sabha. Here the correct answer is option 1, that is a bill pending in parliament shall not lapse because of the prorogation of two houses of the parliament. Question number 5. Which of the following is not covered under Article 20 of the Constitution of India? Options are ex post facto laws, preventive detention, double jeopardy and self-incrimination. Here preventive detention is not covered in the Article 20 of the Constitution. Article 20 talks about the protection in respect of conviction of offences. Article 20 clause 1 talks about the ex post facto law and dual jeopardy. Article 20 clause 2 and self-incrimination is given under Article 20 clause 3. Question number 6. Which one of the following statements is correct? A joint session of the parliament shall be convened by the speaker under Article 108, presided over by the senior most member of the house, convened by the president under Article 108 to break impasse in the passage of a bill. Here option 3 is the right answer. Article 108 talks about the joint sitting of parliament called by the President of India. Question number 7. Which one of the following pairs is correctly matched? Options are writ of habeas corpus available against private individual as well, writ of quo warranto available against subordinate courts only, writ of certiorari available against autonomous bodies only, and writ of prohibition available against public servants only. Here the correct match is option 1, that is writ of habeas corpus available against private individual as well. Question number 8. Which one of the following is not an automatic consequence of the proclamation of emergency? Suspension of enforcement of fundamental rights except those conferred by Article 20 and 21. Extension of union's executive power to issue directions to any state as to the manner in which the executive power has to be exercised. Option 3. Extension of power of parliament to the making of legislation in regard to the items of the statelets. And option 4. Suspension of Article 19. Here it has been asked which of the following is not an automatic consequence. That's why the option first will be the right answer. Question number 9. Indirect interference in the field of another legislature is known as obiter dicta, non-compos, harmonious construction, colorable legislation. Correct answer is colorable legislation. Question number 10. Consider the following statements to answer this question. Parliament cannot extend the jurisdiction and power of the Supreme Court. No discussion can take place in Parliament with respect to the conduct of the judge of the Supreme Court and discharge of his duties. A retired judge of the Supreme Court cannot appear or plead in any court or before any authority within the territory of India. The salaries and allowances of the Supreme Court are fixed by the Constitution and charged by the Consolidated Fund of India. In this question, correct answer is option 1, that is B, C and D. Only A is not correct. Question number 11. A question between A and B is whether a certain deed is or is not forged. A affirms that it is genuine while B says it is forged. Here, option first, A can prove a statement by himself that a deed is genuine. Option B, B can prove a statement by himself that deed is forged. And option 3, both 1 and 2 are correct. And option 4, both 1 and 2 are wrong. In question number 11, option 4 is right. That is both 1 and 2 are wrong. Question number 12. Recovery made by a police officer under section 27 of Evidence Act before recording the formal arrest of the accused is legal, illegal, irregular and improper. Correct answer is legal. Section 27 of Evidence Act talks about how much of information is received from accused may be proved. Now let us see the question number 13. Question number 13. Assertion. Even for a child born immediately after marriage, presumption of legitimacy under section 112 of the Evidence Act would apply. Reason. The legislature which extend the period of operation of the presumption by 280 days after dissolution of marriage did not choose to exclude any minimum initial period of matrimony for the application of the presumption. Here the correct answer is option first, that is both A and R true and R is the correct explanation of A. Section 112 of the Evidence Act talks about the birth during marriage, conclusive proof of legitimacy. Who among the following is liable to explain the injuries to the accused in a murder trial? Correct answer is prosecution. Question number 15. A client says to B, an advocate, I wish to obtain possession of property by use of a forged deed on which I request you to sue. Here the correct answer will be the communication is not protected from disclosure. Now let us see the question number 16. Confession of one accused is admissible against the co-accused if they are tried jointly for the same offense. Question number 17. Mark the incorrect statement. The terms relevancy and admissibility are coextensive and interchangeable terms. This is the incorrect statement. So first option is the right option. Section 91 of the Evidence Act permits admission of oral evidence to prove contents of a document where the writing is a fact in issue. Prohibits admission of oral evidence to prove the contents of a document where the writing is a fact in issue. Prohibiting admission of oral evidence to prove the contents of a document where the writing is not a fact in issue and is merely a collateral memorandum. Both second and third. Correct answer is option second. Prohibits admission of oral evidence to prove the contents of documents where the writing is fact in issue. Question number 19. In which of the following is not correct? In a rape trial, evidence of previous good character of the accused is relevant. In a rape trial, evidence of character of the victim is not relevant. In a rape trial, evidence of previous sexual experience of the victim is relevant. None of these. Here, third answer is right. In a rape trial, evidence of previous sexual experience of the victim is relevant. Question number 20. Which of the following facts the court may presume to exist? Option. When a woman states in her evidence before the court that she did not consent for sex. Option second, a child will never lie. And option third, a priest will always speak truth. And option four, all of these. Here the option first is the correct answer. When a woman states in her evidence before the court that she did not consent for sex. Question number 21. Delay in filing within a prescribed period may be condoned by the court upon showing sufficient cause under Section 5 of the Limitation Act in the case of suit, appeal, and application under Order 21 and all of these. Correct answer is suit. Question number 22. For exclusion of time of proceeding bona fide in court without jurisdiction, the time during which a former civil proceeding was pending, the day on which that proceeding was instituted and the day on which it ended shall both be counted. A plaintiff or an applicant resisting an appeal shall be deemed to be prosecuting a proceeding. Misjoinder of parties or cause of action shall be deemed to be a cause of the like nature with defect of jurisdiction and all of these. Correct answer is option 4, that is all these. Question number 23. A gave a loan of rupees 1 lakh to B against a pro note which became due from payment of 1/1/2014. A dies on 31st December 2013, leaving behind a sole legacy heir S, who was born on 1st January 2000. When would the period of limitation for filing a suit for recovery of S shall begin to run? Correct answer is 1/1/2018. On 2018, he will become 18 years. Question number 24. In computing the period of limitation for any suit, the time during which the defendant has been absent from India will not be excluded, may be excluded in the discretion of the court, shall be excluded, none of these. Here the correct answer is option 3, shall be excluded. Question number 25. For a fresh period of limitation to begin from time of acknowledgement of liability under Section 18 of the Limitation Act, it is necessary that the acknowledgement must be in writing, made before the expiration of the prescribed period, signed by the party against whom right is claimed, all of these. Correct answer is option 4, that is all of these. Question number 26. Pending decision on the objections to an arbitral award, an application for appointment of receiver may be proved, cannot be filed as a matter of right, may be moved with the special leave of the court, both second and third. Correct answer is option first, may be moved. Question number 27. An arbitral award may be set aside in the court if it is in conflict with the public policy of India, a party under the same incapacity, it is held by the local court holiday. Both 1 and 2nd, that is option 4 is the correct answer. Masonic profits are defined under section 2 clause 12 of CPC, means those profits which the person in wrongful possession of such property actually received or might have received together with interest. Option first is the correct answer. Question number 29. On production of a certified copy of a foreign judgment, the presumption as to the competency of the court under section 14 of CPC is a presumption of fact and law both, rebuttable presumption of law, irrebuttable presumption of law. Here the correct answer is 29(3), rebuttable presumption of law. Question number 30. Mark the incorrect proposition. Set off is a statutory defense to plaintiff's action where a counterclaim is cross action. Set off and counterclaim arise out of the same transaction. Set off should not be barred on the date of the suit, while the counterclaim should not be barred on the date of filing of written statement. Claim for set off cannot exceed plaintiff's claim, whereas counterclaim exceed the plaintiff's claim. Both set-off and counterclaim cannot exceed the pecuniary jurisdiction of the court. Select the correct answer using the code below. Correct answer is option second, that is B only. Set-off and counterclaim arise out of the same transaction. This is the incorrect proposition. Other options are correct, that is A, C, D, E is correct. And this proposition is not correct. That is why this is the right answer. Question number 31. Mark the correct statement. The questions which are put only to test the credibility of a person will not be allowed as interrogatories, although they may be asked in cross-examination. Interrogatories may be administered only to a party to a suit and not to a witness, whereas cross-examination can be of any person, parties or witness alike. A party filing affidavit in reply to interrogatories can neither cross-examine nor adduce evidence to contradict it, as it is a conclusive proof. All of these. Now let us see the question number 32. An executing court cannot determine the questions relating to which of the following. Options are execution of decree, discharge of decree, satisfaction of decree, modification of decree. Here the correct answer is option 4, that is modification of decree. Question number 33. Which of the following statement is correct? An attachment order come to an end by A. Satisfaction of decree, B. Setting aside or reversal of decree, C. Dismissal of execution application for decrees holder's default, and E. Death of decree holder, E. Agreement compromise between the parties. Select the correct answer given the code below. Here the correct statement, that is correct answer is option A, that is A, B, C and E. Option D is not the correct answer. Other statement A, B, C and E is the correct statement. Which of the following statement is correct? An appeal pending before an appellate court does not by itself operate as stay of the proceedings under decree appealed from. The appellate court has a power to stay the execution of such decree. Third option, both 1 and 2, and option 4, none of the above. Here the correct answer is option 3, that is both 1 and 2. Which of the following orders cannot be appealed against under the Code of Civil Procedure? An order to set aside for dismissal of suit, an order to set aside decree passed ex parte, an order for a grant of temporary injunction, none of the above. Correct answer is option 4, that is none of these. Question number 36. Which of the following propositions is incorrect with regard to the oral examination of property by a court under Order 10 Rule 2 CPC? The examination need not be restricted to allegations in a pleadings of the other party but can relate elucidating any matter in controversy by the suit. The court can examine not only the parties but any person accompanying either party to the suit. The statement made during the course of examination is not an oath. The court can cross-examine any of the parties with reference to document. Here, the incorrect statement with regard to oral examination is option 4, that is the court can cross-examine any of these parties with reference to document. This is the right answer, but other statement 1, 2 and 3 is the right answer. Right statements, but option 4 is the right answer. Under section 152, an order can be corrected by the court where there has been a clerical mistake, an arithmetical mistake, an error caused by an accidental slip or omission, all of these. Correct answer is all of these. Section 152 CRPC, clerical or arithmetical mistakes in judgments, decree or order, or errors arising therein from any accidental slip or omission may at any time be corrected by the court either of its own notion or on the application of any of the parties. Question number 38. Provision of section 304 of the Code of Criminal Procedure applies only when in a trial before the accused is not represented by a pleader and it appears that he does not have sufficient means to engage a pleader. Correct answer is option 2, Code of Session. Section 304 of CRPC talks about the legal aid to the accused at a state expense in certain cases. Now let us see the question number 39. A magistrate to whom a complaint is made under section 340 and 341 of the Code of Criminal Procedure shall proceed as far as may be to deal with the case as if it were instituted on a police report. This is the correct answer. Question number 40. Filing of FIR is a condition precedent to the exercise of power under section 438 of the Code of Criminal Procedure. The statement is true, false, partly correct, none of these. Correct answer is false. Question number 41. A magistrate has the power under the Code of Criminal Procedure to direct the police to investigate into a non-cognizable offence, cognizable offence, only a non-cognizable offence. As in a cognizable offence, the police is under the duty to investigate for both 1 and 2. Correct answer is option 4, both 1 and 2, a non-cognizable offence and cognizable offence. Question number 42. A case which includes cognizable offence and non-cognizable offence is a cognizable case but requires sanction of the magistrate for investigation into a non-cognizable part. Option 2, cognizable case and as such the investigation of the case does not require any sanction of the magistrate. And option 3, non-cognizable case and as such the investigation of the case requires sanction of the magistrate. And option 4, non-cognizable of the case but does not require any sanction of the magistrate. Here the correct answer is option 2, that is cognizable case and as such the investigation of the case does not require any sanction of the magistrate. Question number 43. For the purpose of computation of the period of 90 days or 60 days, as the case may be, for the purposes of section 167, subsection 2 of Code of Criminal Procedure, the day of arrest of the accused has to be excluded, on which the accused has remanded is to be excluded, of the arrest accused and the day on which the accused was remanded indifferent, both have to be excluded. Correct answer is option 3rd. Question number 44. Non-compliance with the provision under section 191 of the Code of Criminal Procedure, where cognizance is taken by the magistrate under section 190, subsection 1 clause C of the Code of Criminal Procedure. Option first, vitiates the trial and proceedings and will be wholly void, is an irregularity curable under section 460 of criminal procedure, does not vitiate the trial unless it has caused the prejudice to the accused, amounts to waiver of his rights of the accused. Here the correct answer is option first, vitiates the trial of the proceedings will be wholly void. Question number 45. When is an investigation officer bound to videograph the proceedings during the investigation? Options are identification of the driver of the offending vehicle by physically disabled victim of road accident. Option second, recording of the statement of rape victim under the mental trauma, both 1 and 2 and none of these. Correct answer is option first, identification of the driver of the offending vehicle by the physically disabled victim of road accident. Question number 46. Sanctions for prosecution of judges and public servants shall not be required under section 197 of CRPC in a case a judge or public servant is alleged to have committed. Correct answer is option first, voyeurism. Section 197 in detail discuss the provision of prosecution of judges and public servant. Now let us see the question number 47. All evidences taken in course of trial shall be taken in the presence of the accused except in the following circumstances: a minor girl victim of kidnapping, an old person witness of murder, a minor girl victim of rape, a physically handicapped woman victim of road accident. Correct answer is option 3rd, that is a minor girl victim of rape. Question number 48. A intending to murder B by poisoning purchases poison and mixes the same with a glass of water. He gives the glass to the bearer to serve B. The bearer, while approaching B, loses balance and the glass drops out of his plate. Which one of the following statement is correct? A has committed no offense. A has committed the offense of attempt to commit culpable homicide. A has committed the offense of abetment. A has committed the offense of murder. And question number 48, correct answer is option 4. A has committed the offense of attempt to murder. Question number 49. Planning to commit theft is a cognizable offense, no offense in itself, strict criminal liability, conspiracy. Correct answer is no offense in itself. Question number 50. An accused person was charged under section 302 read with section 149 IPC. The existence of common intention among the accused person was established from the surrounding circumstances and from their conduct on the spot. No charge had been framed under section 34 IPC. In such case, it is not possible to convict the accused with the aid of section 34. It is possible to convict the accused with the aid of section 34. Second option is the correct answer. Question number 51. The accused found a deceased engaged in sexual intercourse with his 15-year-old daughter. The accused assaulted the deceased on the head of a spade, which resulted in death. Accused claimed private defense. The prosecution led evidence to show from sexual intercourse was the consent. Here, accused is entitled to the right of private defense since the girl was a minor, being only 15 years of age. Option first is the correct answer. Section 52. In IPC, the death of trespasser of the house who was escaping is first murder, second no offense, exception to section 300. Correct answer is exception second to section 300. Which of the following offense defines the offense of trafficking? Recruitment of adult men by depicting or for illegal mining, receiving minor boys by abduction for begging, transporting women, inducement for sexual exploitation. All of these. Correct answer is all of these. In which of the following circumstances a woman in exercise of a right of private defense of the body can cause the death of the perpetrator? When a man demands a request for sexual favors, when a man attempts to throw or administer acid which may reasonably cause the apprehension of grievous hurt. This is the correct answer. 54. Second option is the correct answer. Question number 55. Which of the following acts will amount to the offense of stalking? A postgraduate student walking behind a female teacher, a police officer following a woman for detection of crime, a male colleague monitoring the emails of female colleague. This is the correct answer. Stalking is defined in section 354D of IPC. Question number 56. A boy from Manipur, a student of Delhi University, suffers acid attack in a brawl during college fest. He is rushed to a private hospital for treatment by his friend. The hospital refuses to treat him being a police case and asked him to go to the government hospital. The private hospital here commit the offense of non-treatment of victim of acid attack. This is the right answer. Question number 57. Which one of the following conducts of a police officer would be an offense? Calling 67-year-old retired government servant to the police station during the investigation of a multi-crore scam case. Calling a 14-year-old boy with parents to the police station during the investigation of a doll murder in the neighborhood. Option 3rd, failing to record FIR on the basis of information of women being paraded naked. Option 4, all of these. Here the correct answer is all of these. Question number 58. If only a part of the consideration or object is unlawful, the contract under section 24 of the Contract Act shall be option third, void as whole. Section 24 of the Indian Contract Act talks about if any part or single consideration for any or more objects or any part of any one of the several considerations for a single object is unlawful, the agreement is void. Question number 59. X agreed to supply 1000 tons of iron at rupees 100 per ton to F to be delivered not later than 31st January 2013. X has entered into a contract with A for purchase of 1000 tons of iron at rupees 80 per ton, telling A clearly that the iron is needed before 31st January 2013. Supply to Y to fulfill the contract with F. A fails to supply the iron to X, who in turn failed to supply the same to F. In an action by X against A, X can recover damages for the loss of profit at the rate of rupees 20 per ton, that is the loss of profit. X can recover damage for the loss of profit he would have earned by timely supply to Y, and also damages which X might have paid F on the account of breach of contract. This is a correct option, that is option second. Ramesh and Geeta were husband and wife living in Bangalore. Ramesh was an income tax officer and Geeta was a school teacher. They had two sons studying in schools in Bangalore. Parents of Ramesh were also staying with them. Ramesh was transferred to Madras and he had to leave his family behind at Bangalore. He promised to send every month rupees 30,000 to meet the family expenditure to his wife. Ramesh did not send any money from Madras. If Geeta filed a suit for a specific performance of the contract, then which from the following is correct? Family agreements are not contract, hence no order for specific performance can be ordered. First option is the correct answer. A owes B rupees 2000, C pays B to rupees 2000 and B accepts in satisfaction of his claim against A. This payment is not a discharge of the whole claim, is a discharge of the entire claim. Second option is the correct answer, is a discharge of the entire claim. Question number 62. A and B go into the shop. B says to shopkeeper, let him have the goods, I will ensure that you are paid. This is a contract of indemnity. Section 124 of the Indian Contract Act defines the indemnity, a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. Question number 63. J, a usual customer of B, orders certain goods on the day on which B transfers his business to the plaintiff. The plaintiff accepts the order and supplies the goods. Thereupon, J refuses to pay, alleging that he has intended to contract only with B, since he is having a set-off against him. In this situation, J has no liability to pay the price because he has never intended to contract with the plaintiff, is liable to pay as he has already been supplied in response to his order, is liable to pay because plaintiff has supplied the goods as an agent of B, is liable to pay because he can claim reimbursement from B. Here the correct answer is option first, has no liability to pay the price because he has never intended to contract with the plaintiff. Question number 64. A supplies B, a lunatic, with necessaries suitable to his condition in life. Will A be entitled for reimbursement from the property of B? Yes, he will be re-entitled. So correct answer is option third, yes. Question number 65. A hires a car on a rental from B at Kolkata for going to Varanasi. A takes the car but rides to Bhubaneswar instead. On the way to Bhubaneswar, the car met with an accident. A is liable to pay the compensation for damage to the car. Question number 66. A employs B to beat C and agrees to indemnify him against all consequences of the act. B thereupon beats C and has to pay damage to C for doing so. Determine the liability of A. Here A will not be liable to pay any damages. Question number 67. A authorizes B to buy rupees 500 cows for him. B buys 500 cows and 300 cows for one sum of rupees 50,000. A is liable to pay, not liable to pay any sum. Question number 68. When a minor is admitted to the benefits of partnership, such minor will have the right to agreed share of profits of the firm, may inspect the accounts of the firm, will not be personally liable for the acts of the firm. And option 4, all of these. Here the option 4 is the correct answer. D, a partner of the business firm dies and surviving partners carry on the business with property of the firm without final settlement of account. The firm makes profit. Widow of D would be entitled to, options are share in profit, interest at the rate of 6% per annum, third both 1 and 2, and option 4 either 1 or either 2. And here the correct answer is option 4 either 1 or 2. Question number 70. A statement, intimation or notice recorded in the register of firm shall as against such person by whom on whose behalf such a statement, intimation or notice was signed. Correct answer is conclusive proof of fact. Question number 71. Partners of an unregistered firm enter into an agreement and let out its premises on rent. In case of default of payment, the partners can file suit for eviction. Question number 72. Implied authority of a partner as agent of the firm under section 19 of the Partnership Act does not empower him to compromise or relinquish any claim by the firm, withdraw a suit filed on behalf of the firm, admit any liability in a suit against the firm, and all of these. Here the correct answer is option 4, that is all of these. Question number 73. A suit filed by the plaintiff P and against D under section 6 of the Specific Relief Act is decreed in favor of P. The remedy against the decree of D is to file an appeal, revision, review, both 1 and 2. Correct answer is revision. Question number 74. Defendant is in possession of 120 cotton bales as an agent of the plaintiff. Plaintiff files suit for specific performance of the contract against the defendant to compel the delivery of the same. The relief claimed can be refused on the ground compensation in terms of money would afford adequate relief. It would be difficult to ascertain actual damage, both first and second, none of these. Correct answer is option first. Compensation in terms of money would afford adequate relief. Question number 75. A files a suit for mandatory injunction against illegal disconnection of electricity. A also suffers loss in the business on account of non-supply of electricity. The suit for mandatory injunction is dismissed. A thereafter files a suit for damages for suffering loss. The subsequent suit is barred under the Specific Relief Act. Question number 76. In a suit for a specific performance of contract, the plaintiff must aver and prove that he is ready and willing to perform his part. He has actually tendered the money to the defendant, both first and second, and none of these. Correct answer is he is ready and willing to perform his part. Question number 77. A declaration made under the Specific Relief Act is binding the parties to the suit and person claiming through one, both first and second. Question number 78. The doctrine of lis pendens would apply against the defendant who has transferred immovable property from the date of filing of the plaint, servings of notice, appearance before the court, and hearing by the court. Correct answer is filing of the plaint. Question number 79. Which one of the following conditions is invalid as per section 10 of the Transfer of Property Act 1882? A condition not to sell outside the family, a condition not to sell to a person of different community, a condition not to sell during the lifetime of the transferee, and a condition the lease that the lessee shall not sublet his interest to anyone. Here the invalid condition is asked, therefore answer option 3 is the correct answer. A condition not to sell during the lifetime of the transferee is the correct answer. Question number 80. In the absence of written contract, a lease of immovable property for the purpose other than the agriculture or manufacturing shall be deemed to be a lease from the month to month, terminable by 15 days notice. The period shall commence from the receipt of notice. Question number 81. A lets a house to E for 5 years to B, under lets house to C at a monthly rent of rupees 1000. The 5 years expire but C continues in possession of the house and pays the rent to A. C's lease is renewed from month to month. That is the correct answer. Question number 82. Transfer of immovable property by way of gift requires registration of the instrument signed by or on behalf of donor, attestation by at least 2 witnesses, delivery of property, both first and second. That is option number 4, both first and second is the correct answer. That is registered instrument signed by or on behalf of donor, second attestation by at least 2 witnesses. Question number 83. Where the wife, a homemaker, does not comply with the decree of restitution of conjugal rights under section 9 of Hindu Marriage Act 1955 and instead files for divorce and maintenance, she would not be entitled to claim maintenance, be entitled to claim maintenance, be entitled to claim only starvation allowance, be entitled to claim maintenance only from the date she complies with the decree for restitution of conjugal rights. Here the correct answer is option second, be entitled to claim maintenance. Question number 84. Section 27 of the Hindu Marriage Act 1955 allows the court to divide which one of the following between the spouses: property acquired by them out of their earnings before the marriage, property acquired by them out of their earnings after the marriage, property presented to them jointly at the marriage, property acquired through the inheritance by the husband. Here the correct answer is option third, property presented to them jointly at the marriage. Section 27 of the Hindu Marriage Act talks about the disposal of property. In any proceeding under this act, the court may make such provisions in the decree as it deems just and proper with respect to any property presented at or about the time of marriage, which may belong jointly to both husband and the wife. Question number 85. Which one of the following is not a kind of domicile? Domicile of choice, domicile of status, domicile by operation of law, domicile of origin. Correct answer is option second, that is domicile of status. Question number 86. The statutory bar, no petition to be presented within 1 year of marriage under section 14 of the Hindu Marriage Act 1955 is imposed on the petitions for. Options are divorce, judicial separation, annulment of marriage, both first and one. Correct answer is divorce. Question number 87. An application under section 24 of Hindu Marriage Act 1955 needs to be disposed of within 30 days from the date of service of notice on the wife or husband as the case may be. Option second, 60 days from the date of the service of notice on the wife or husband as the case may be. Option second is the correct answer. Question number 88. A decree by restitution of conjugal rights can be executed under Order 21 CPC by detention in civil prison, either by detention in civil prison or attachment of property, detention in civil prison and attachment of property and attachment of property. Option 4 is the correct answer, that is attachment of property. Question number 90. Which of the following is not a ground for divorce under the Hindu Marriage Act 1955? Respondent suffering from virtual and incurable form of leprosy, respondent converting to Buddhism. This is not the ground for divorce under the Hindu Marriage Act 1955. Option second is the correct answer. Question number 91. Which of the following is not a Hindu under the Hindu Marriage Act 1955? A legitimate child whose father is Hindu and the mother is Parsi and he brought up as a family member of the latter. An illegitimate child whose father is Sikh and a mother a Buddhist. A reconvert to Buddhism, a Vaishnava religion. Here the option first is the correct answer. Which of the following propositions with regard to an application under section 25 of Hindu Marriage Act 1955 is incorrect? An application under section 25 can be made before passing of the decree under section 13 clause 1 subsection B. An application under section 25 can be made at the time of passing of the decree under section 12 of Hindu Marriage Act 1955. An application under section 25 can be made subsequent to the passing of the decree in petition under section 13 subsection 2 clause 4. An application under section 25 can be made subsequent to dismissal of the petition for divorce under section 13 subsection 1 clause IA. Here the incorrect proposition has been asked, therefore option 4 is the correct answer. Section 25 of Hindu Marriage Act is related to the permanent alimony and maintenance. Now let us see the question number 93. A property acquired by a female as co-partner can be disposed by her by way of testamentary disposition, gift, both 1 and 2. Here the option 3rd is the correct answer, both 1 and 2. Question number 94. Property acquired by male under Hindu succession 1956 is his separate property, ancestral property, separate property in relation to the existing member, none of these. Correct answer is separate property. Question number 95. Property acquired by a female Hindu in lieu of maintenance in 1953 and gifted by her in 1955 and re-gifted to her in 1958 becomes her absolute property, does not become her absolute property, remains her limited estate, none of these. Correct answer is her absolute property. Question number 96. A joint Hindu family consists of the father F and his sons S1 and S2. In a sudden fight between S1 and S2, S1 is killed and later father dies. S2 is entitled. Entire property of F. This is the correct answer. Question number 97. A joint Hindu family consists of father F and his 3 sons S1, S2 and S3. S1 converts to Christianity in 1960. S2 suffers from leprosy and F dies in 1961. Who as heir can inherit the property of F? Correct answer is all the 3 sons. In the words not negotiable are used with general crossing in a check. The check is not transferable, transferable, negotiable under certain circumstances, none of these. Correct answer is transferable. Question number 99. If a minor draws, endorses or negotiates a negotiable instrument, such instruments binds all parties to the instrument including the minor, only the minor and no other parties to the instrument, all parties to the instrument except the minor, none of these. Correct answer is option 3rd, that is all parties to the instrument except the minor. Question number 100. In the absence of the contract to the contrary, the liability of the maker or drawer of a foreign promissory note, bill of exchange or check is regulated in all essential matters by the law of the place where the instrument is made payable, endorsed, made, all these. Here the correct answer is option 3rd, that is made. Black holes are places where gravity is so powerful that draws even the light. Question number 103. Strongest muscle of the body is located in jaws. The only major organ of the human body that can regenerate itself is liver. Periyar Wildlife Sanctuary, famous for its large elephant population, is situated in Kerala. The first creatures launched in outer space in captured Nazi 5-second rocket are fruit flies. Question number 107. Unauthorized access to computer system by passing the security mechanism of the system or network is called hacking. The Armed Forces Flag Day in India is dedicated towards collection of funds for the welfare of the Indian Armed Forces personnel. This is the right answer. Question number 109. The indigenously developed light combat aircraft to join Indian Air Forces Tejas. The International Court of Arbitration is an institution for the resolution of territory disputes between the two countries, international diplomatic conflicts, international commercial disputes, dispute arising out of the breach of the treaty between the two countries. Correct answer is option 3, that is international commercial disputes. The film Gaj Gamni, released in the year 2000, was directed by, correct answer is painter M.F. Hussain. Question number 116. Hours means unwilling. Question number 117. Find the correct option from the following. You shouldn't live for memories of your childhood, on memories of your childhood, after memories of your childhood, memories of your childhood. Correct answer is second option, on memories of your childhood. Which one is spelled this correctly? Correct answer is nocturnal. Question number 119. Choose the word that has similar relationship. Medicine, illness, law. Correct answer is option second, that is discipline. Complete the gap. I don't like black coffee. I usually have it with 2 sugar and 1 milk, many milk, 2 pieces of sugar, milk and sugar. Correct answer is milk and sugar. Identify the correct expression. If I had known you, I would hurt him so much. I dash that. Options are couldn't have said, must have said, wouldn't have said, will say. Correct answer is option third, wouldn't have said. If I had known I would hurt him so much, I wouldn't have said that. Question number 122. Chemical fertilizers are used to dash to the soil. Soften, barren, enrich, cultivate. Correct answer is option third, that is enrich the soil. Choose the word that has similar relationship. Entomologist, insects, philosopher. Correct match for this is ideas. Question number 124. Choose the meaning in the phrase in the black. Inside a wall, black hole, financially sound, outside the black circle. Correct answer is option third, that is financially sound. So that's all. This is the last video in related to the discussion of Delhi HJS previous year's papers. Now in this timeline you can find the 4 previous year's question papers we have solved: 2019, 2017, 2015 and this paper, that is 2013. I hope you have liked the entire video, and definitely this lecture series would have helped you in your preparation. Please like, share and subscribe our channel, and please also join our Telegram channel, the link of which is given under the description section. Thank you so much. Thank you for watching.